Good morning. Thank you all for coming to join us today. It's a privilege and an honor to be speaking. My name is Daniel Geary. This is my colleague David Cass. You want to introduce yourself?
Yeah, sure. David Cass, senior partner with Law and Forensics. Also been managing director for a GSR, a crypto market maker, one that is not in trouble. Adjunct faculty at Harvard, along with Daniel, and prior history, longtime financial services CISO, as well as I am a former regulator from the Federal Reserve, and I see alumni from the Federal Reserve here as well. So any comments I make today are not that of the Federal Reserve. They are my opinion and mine alone.
So it's always my opinion. I teach at Harvard. I'm a serial entrepreneur. I founded several companies. I have a law degree, worked at the Supreme Court, blah, 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 written a lot of articles, trained federal judges. Full disclosure, I was on the U.S. Attorney team on the Sullivan trial, which seems to be very popular. On topic of conversation, I serve as a technical expert witness for the U.S. government, some of the largest high-stake trials in the country. Presentation today is my own comments, blah, blah, blah. This is not legal advice. If you do need a legal advice, hire a lawyer. With all of that said, I have a couple questions for y'all. I was going to say, since I teach, I was going to make everybody sit in the front, come in the back, come forward, but I won't. But in full disclosure, we want it to be as interactive as possible, so I'm going to kick that off with some basic questions. Who here works in information security? Just raise your hand. Who here practices law? Who here is hired as chief security officer and a lawyer for their company in both capacities? And serving as legal counsel and as chief security officer. So there's, I believe, 6 people in the country, of which 1 is in the room, in that role and capacity. And who's worked for well, anyways, so today's conversation should be interactive, and if you have questions, feel free to participate and ask questions and engage. With all that said, we should kick it off now.
Yep.
All right. So with that said, here's the official disclaimer in case you want to read it. It's written out for you. I think it's available. You can download it. With that said, our focus today is really on a series of issues. And I guess the first question we talk about is a bug bounty. So since everybody pretty much raised their hand as to working information security, I'm going to go with as a safe bet. You all know what a bug bounty is. Maybe, David, you can sort of walk through functionally what is the bug bounty, and then we can sort of talk about the guardrails around it.
Again, usually most bug bounty programs are, you contract with an outside provider and you set up, the ground rules for using, ethical researchers or ethical hackers to actually, test your systems for different vulnerabilities. And you'll usually, set various ground rules around it. Bug bounties are legal. They do help a lot of companies. They provide positive results, but we'll start talking about frameworks that need to be put around it.
So there are a couple of things I think should be talked about. The word hacking has been desecrated because the idea of hacker isn't a bad thing, right? Hacking is a function of entering someone's network, right? Without authorization or with authorization, that's different. It's the act of entering a network, right? With using whatever tools and gaining access to the network, right? That you should, not using traditional means. Now, if you don't have the intent and someone hacks into your company, this is where this whole gray line starts to get a little blurry, right? Because a bug bounty is effectively paying someone to say, where are the holes in our organization, right? So you can pay someone to hack in, right? The red team them, purple team, blue team, pink team, whatever color team you want, right? The functional idea is you're hiring someone or they are attempting, because you've posted rules or rules of engagement, to enter your network, to enter your systems, right? And then you say, well, this is what you can do when you're there. You can't wipe all our data. You can't ransomware us, right? So the question then becomes, where is that line set? Where does that demarcation happen? But you as the person running the program aren't breaking any laws by paying someone that enters and accesses your network as long as they're not on an OFAC list. Or if you want to, the OFAC list is sort of the proverbial US naughty list, right? Meaning you can't deal with these individuals because if you do, they're considered sponsors or threats to the interests of the United States government. So as long as you're not paying one of those individuals, the rest of it is sort of a very gray area, right? So you need to set the rules. So people, if you have questions, feel free to raise your hand.
And I would just add, building on that, where you talk about, how many people have been contacted by outside ethical researchers? Lots of people have, and there's means of, having that interaction that we'll talk about. But one of it is also being able to positively identify that individual. I've been contacted at a bunch of the normal organizations that I've been with, and a lot of times that initial contact email or that initial contact name isn't the name until you start going through the process and actually speaking with the person.
But that's tied to the need to make sure you're not paying a terrorist, right? The reason why you need to verify identity, right, is when you're paying someone, you don't want to fund a terrorist organization or a criminal syndicate or somebody that was counter to the interests of the United States. If you want to pay someone that's a despicable human being that so happens to enter your network, God bless. I mean, that's a reflection of how your company wants to operate and whatever. But that's a very clear demarcation, right? There is a very clear set of people, like oligarchs and others, that if you end up paying them money and they are not permitted individuals, it's strict liability. You can get quite a bit of trouble. It's criminal charges and et cetera. But my advice to anybody in the information security profession is if you're setting up a bug bounty program, not only should you talk to your own in-house counsel, you should also probably talk to outside counsel to verify that the rules of engagement that you're setting up are permissible, right? You're not lawyers. Like, I think there was like two lawyers or three lawyers in the room that are practicing attorneys that are also information security professionals. And it's very important to understand the difference, right? Because when you start looking at a bug bounty, right, you're setting up a bug bounty program. Your job is to create a program for people to contribute and say, hey, look, I was able to gain access to your network. This is the harm we caused, and this is how it plays out, which is fundamentally different than, oh, we broke into your network, we took all your data hostage, and now we're demanding payment. People and defining what those rules are isn't per se the information security team's job, it's the legal's job to tell you this is what you can do, right? And so as long as you stay within those sort of swim lanes, you should be fine. David, we'll jump into the next slide here.
Yeah, I just switched it.
We already did it. Look at that. This is how long we've been talking together. So you want to walk us through sort of, the United States v. Joe Sullivan sort of background?
Yeah, so again, as Daniel mentioned, there was a lot of contributing circumstances. So when you start thinking about this, that hopefully for most people, this should be a very edge case.
I mean, it's not should be. It is an edge case, right? Most CISOs don't serve as AUSA, former AUSAs. Most CISOs don't serve as deputy general counsel. Most chief security officers aren't sitting in a position where they've offered sworn testimony on the penalty of perjury in an ongoing federal investigation or inquiry from a regulator, and then failed to disclose to anybody in their executive leadership team the ongoing circumstances, and then make relevant other representations and attestations and fail to tell the government, right? I mean, they're pretty simple guidelines, right? Tell your in-house legal team. If you're in that very rarefied position where you are part of the legal team, you should have your own independent outside counsel to advise you. In the case of Joe Sullivan, his own lawyer, outside law firm, testified that they were never told about the breach. The important thesis here is that you engage in a conversation with legal, right? And no job's worth going to, like.
Yeah, so when you look at the contributing circumstances, again, the individual was already giving testimony to a regulatory authority.
10 days before.
Exactly, and then 2 weeks later, the additional hack was reported or discovered, and it was not disclosed to the regulator. And again, as a former regulator, there's plenty of times where we meet with our organizations that were regulated, and something happens, and you come back a couple weeks later and offer a clarification.
But as a CISO, you don't have the obligation to tell the regulator unless a very, very narrow set of circumstances. Unless you've testified, offering written testimony, people know about it, and then you failed to tell it. Unless you sit again for the deposition, you can just tell out your in-house counsel, hey, look, we've had an incident. This is what we testified to. We should make this disclosure. Tell the regulator. You tell your legal team. Your legal team will evaluate those risks and make that determination. For the verified CISO that sits in both roles, they should recuse themselves from participating in any part of the legal process of deciding whether to tell the regulator. right? All your job is to do is say, hey, look, I testified to this 10 days earlier. This just happened again. They've asked us to inform them on an ongoing basis of any incidences. I believe this falls within this bucket. We should tell them. That's what you need to tell your legal team.
Yeah.
Then your legal team will do a whole lot of legal analysis, use outside counsel, and look at it because it's a fact-specific exercise. But paying the ransom, participating in a bug bounty, engaging in that process, the government didn't say that you can't do that. I mean, OFAC has said that paying certain people is a crime, but they certainly didn't say you can't set up programs to encourage and foster and use a set of tools to encourage the entire community to help secure your enterprise.
Yeah, and going back to the regulator, if you are the one that faces off to the regulator, if you're regulated in financial services, things like that, there's plenty of opportunity to go back and offer clarification. You may have thought things were fully under control, and then all of a sudden the circumstances change, so then you come back. So overall, at the end of the day, it may not look great that, from a regulatory point of view, that maybe you didn't have a full understanding of the scenario, but you haven't committed a crime.
Yeah, and if you get statements that legal wants to represent to the regulator and you don't correct them and say this incident happened and blah, 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 and instead you ignore it in totality, that will not cut your way. But again, the thesis being, when there's a cyber incident and you call it a bug bounty, that's a gray area, right? That's a very gray area of, were they operating within the guidelines of what you've decided is appropriate? Did they cause harm? Like, at the end of the day, when someone breaks into your network without authorization or consent, there's a law. The law, I think, is on the next slide. Yeah. And it basically says that if you have unauthorized access to a network and cause damage of more than $5,000, you can get in trouble and go to jail. Now, how you define that and how you put those guardrails up, and that's the Computer Fraud Abuse Act. It's really old. They've updated it a couple times. But the thesis being is that if you have an employee, someone that's working for you, and so I was just involved in another case where if an employee is terminated, they don't have authorized access. Even if their credentials still work, it doesn't mean they were fired. They were walked out of the premises. They're not allowed to be there, right? There's no question. They're not authorized to log into your Terraform or your Ansible or your web server or whatever and do a bunch of harm. That is a crime, right? Now, if they're an employee and they're still authorized, that's a different gray area. But the thesis of a bug bounty is the individual doesn't work in your employment, right? They're not an actual they're not an employee at the time when it at least starts, right? And so you're defining guardrails of how you want people to engage and help in that security process. But you certainly need to know who they are under the current legal regimes if you're going to pay them for it, because as I said, you cannot pay people who have interests that undermine that of the United States government that have been identified as such.
Yeah, so how you structure these programs is very important. It's clear that they add value, but having a legal structure to them is extremely important. That dictates, what are the terms of engagement, that if you are going to do ethical reporting, you may have contracted out for, an outsourced company to do your actual bug bounty program, but you still need the terms of engagement, not just for who you contracted with. If you have a broader program where you're going to have outside ethical researchers, pinging you of the things that they found, you want to have, what the terms of engagement are clearly there, and you want to have set up is everybody familiar with what Safe Harbor is, or yes, no? Safe Harbor is essentially, the hold harmless of the releasing from liability as long as you follow the rules. If you break the rules of the engagement, Safe Harbor does not apply.
Now, let's be clear. I'm not saying everybody's illiterate and they don't read, but all I'm saying is that your Safe Harbor, the language of the program and these other things needs to be understandable and intelligible to a non-lawyer, so to speak, right? You have to provide it in a fashion of consumption that allows for appropriate engagement. But it's a tricky part of the process, but you want to make sure you define those guardrails properly, because if you don't, right, as a company, it's just a gray area, right? I mean, the only time you're going to go sideways is if you're the deputy GC, you edit the NDAs, you act in a legal capacity, you don't know who you're paying, you pay them a lot of money, and suing, and you don't disclose it, and all of those pieces that are part of the legal analysis.
And you know, the key thing there also is once you have defined the authorized means, you know, sticking to making sure you adhere to what the agreed upon authorized means were. In the incident that Daniel was referring to earlier, also there was a clear violation. One of the examples of things that would have disqualified you from participating in that bug bounty program was exactly how the hackers obtained the data. And there's very different things too. Of, you know, when somebody reaches out to you as an ethical, you know, researcher reporting a vulnerability, whether you've contracted with somebody or not, there's a certain tone to these emails. And distinguishing a tone of somebody that's an ethical researcher looking to report a vulnerability is very different than the tone of an email demanding payment.
Yes, there's very clear demarcations of rules of engagement. Obviously, if someone ransoms your organization and you pretend it's a bug bounty, I mean, probably problematic. But the truth is that it's quite a bit more gray than that in the process. But the real question is, it's a dynamic of your company culture and how you're functionally operating within your organization, right? I mean, important thing about Safe Harbor, just because you work for a crappy company with a bunch of people that are super hyper aggressive isn't a defense, right? Enron's CFO was charged and he went to jail, right? And arguably, like, the fact that they were shredding documents in the room, right? I mean, you know, and he says, well, it was part of our culture. This is how it worked. Like, newsflash, the federal government doesn't care. Like, a better way to look at this, I have 2 young kids, right? And if they come to me and say, well, Daddy, they were doing it and that, I'm like, come on. Like, I mean, and so when you're playing it, and I think it's a great way to understand your role. You have a seat at the table. A CFO, if they submit fake financial information, they can be charged, right? If a chief marketing officer knowingly and willfully markets products that they know not to be true and operate and product liability law, they can be held liable. So can the corporation, right? I mean, you have a seat at the senior leadership table over organization, and there are levels of accountability and engagement, right? And just if it's a bad culture is I probably wouldn't end up working in that environment, and life circumstances are as such, but the important part to realize is that you, as an individual, have a fiduciary responsibility not to lie to the federal government. You have a fiduciary responsibility not to knowingly and willfully perjure yourself, right? And all of these things, right? And that's not related per se to the case we're talking about. I'm just saying at a general level. And the reason I mention that is, you know, under the False Claims Act, if you sell the United States government and you, the chief security officer, make reps and warranties and sign them, it literally says when you sign the form, like, if you are lying, you can be prosecuted, right? I mean, and it's very important that if you made a mistake, there's a big difference between making a mistake and knowingly and willfully withholding. Right? If you made a mistake, like David, I mean, you should tell him, like, as a former regulator, how it works.
Yeah, I mean, you know, as a former regulator, I mean, organizations make mistakes all the time. It's just, you know, how transparent are you? How proactive are you about the outreach? And you know, what steps are you taking for remediation to make sure that it doesn't happen again? Because it's one thing, you know, as a regulator where we've had findings against many organizations, it's judged differently if you have a track record of consistently having a series of issues, because then it speaks to us of that clearly you're not correcting your problems and things need to be looked at deeper. Is it process? Is it culture? So there's lots of areas to look at. And also, just as a CISO in general, it's clear even, you know, prior to the trial that, you know, the SEC, DFS, there are plenty of regulators that are, you know, announcing their expectations or declaring their expectations that CISOs will be held to a higher level of accountability.
Yeah, I mean, it shouldn't be a surprise that people are, but I mean, they're holding you to a higher level of accountability because it's a function of your role in the job in the organization. If you don't want the job or the role, then you shouldn't take it. But the regulators have made it clear, whether you like it or not, the SEC, the DFS, the CPRA, you can pick the flavor of a regulator. They have said, we expect this person that serves in this role or in this capacity to be functioning at this level, and we will hold them accountable accordingly. But let's be clear, accountable for what? Telling the truth. Accountable for what? Making disclosures to their legal team. Accountable for what? Making sure that if you find out that what you sold somebody doesn't work or isn't secure in the function the way it does, that you go back and you tell them, right? That's what they're saying accountable for, right? Accountable for not being a lawyer, not being a compliance professional. They're holding you accountable for having the conversation, for reaching out to legal saying, hey, look, this has happened. I've made these statements. I mean, and there are edge cases. I mean, Twitter, there are edge cases. And in those edge cases, there is a process. You can file a whistleblowing. There are a set of processes to file. If you feel that you're functionally being complicit in breaking the law, right? And it's not, nobody says it's easy. Nobody says it's fair, right? But if the chief financial officer is getting numbers that he knows is fake, and he files them with the Securities Exchange Commission, full knowledge that the financial information he's submitting is fake, I promise you the SEC isn't going to be like, I'm sorry, peer pressure must have been too much. We're going to give you a free pass, even though the entire market decided to buy and sell your stock based on the fake financial information you decided was okay to submit. Right? I mean, there's a functional level of engagement, right, that I think is very clear as to what the expectations are. I think that most CISOs should have some legal resource available to them, right? You're not the lawyer. You shouldn't act as the lawyer. You should say, I don't know the law. This is what's happened. Somebody from legal needs to tell me what is the appropriate course of action.
And that's actually a great point. I mean, even outside of bug bounty programs, ethical reporting, and things like that, you should already have a good rapport with your chief legal counsel and the legal teams that are there. Because again, whether it's for incident response, whether all of this is a team sport now. None of this should be done in isolation.
Yeah, I mean, you don't have to be drinking buddies or anything, but you should at some level have a functional relationship so you can manage the risk. Right? You get into a much grayer area. I mean, here are the simple don't do's. Don't hire contractors to go to other people's homes, pretend to be federal officers, have them sign fake documents, and then pretend that it's okay under a bug bounty program, right? There's some basic rules of engagement that you shouldn't stray upon, right? But outside of these cases, most people I deal with and work with, you're ethical, honest people, and frankly, no job is worth going to jail for. No job is worth putting it on the line, right? If you feel that you don't know the answer, just say, I don't know. Hey, legal, this is what I did. This is what I think should happen. What should I do? Right? I mean, that's the functional conversation, right? I mean, and I think it's really important. But I mean, there are other tools, like bug bounties are one tool to managing risk. You can do risk assessments, you buy tool. I mean, just walk down the hall. There's like 5,000 vendors. There are tools, there are assessments, there's all of tabletops. There's a litany of tools that you can use. Bug bounty programs is just one of those tools, right? And you should use all these tools, they call it, isn't it defense and depth, right? Depending on how you structure and utilize these functional things. Anything you want to add?
No, I mean, and again, that's it. I mean, the bug bounty programs definitely have a place. And also, by the way, if you guys have questions, comments.
Oh, they're all hypothetical.
Feel free to ask as we're going along, because we want this to be interactive.
Yeah, so. If you have questions, we're just going to assume they're hypothetical and we're not giving you per se advice.
Yeah, I just question, because of my role, I had to familiarize myself with the NIST 853. And one of the requirements was to put a screen up that before you log into the application for a government application, and it basically says if you log into the system for nefarious reasons or whatever, you're going to get prosecuted under a penalty of law. How do you run a bounty program where you're going to pay somebody that's going to hack past that splash screen to resolve that with, they could get prosecuted, but then they're doing something. But by the same note, we've had people contact us that say they're Vietnamese cyber researchers, and they point out a hack or something. So, but how do you resolve they could go to jail versus you're paying them?
That to me is it's not so complicated, right? You have federal contracts that say we're going to maintain a certain level of security standard and access to our systems. You entered into business with the federal government. You agreed to follow those rules and laws and enforce them accordingly, right? And by agreeing to participate in that, you've agreed that as we are servicing the United States government as a customer, and we've agreed that they're basically saying we're not okay with you paying people to hack in to systems that you're using to provide support to our organization. Now what you should do is hire outside counsel, because I don't know the specific, there's DFARS and there's CMMC-AB. There's a litany of different contractual obligations, and you usually have a GSA contract with reps and warranties. So you should have a lawyer that knows what they're doing in government contracting, look it over, analyze it, right, and say, are we permitted under our contract schedule and under the law to actually pay people under the contract terms we've given, or if we do this, are we violating our contract with the government, right? And then you'll be able to figure it out. But I mean, at the end of the day, if it pops up the alert and it says you're going to prosecute people, and some lawyer put it there pursuant to terms of your contract, my advice to you is I would go back to them and say, hey, look, we have a problem because we have people coming to us as ethical hackers or whatever in Vietnam or Chile or wherever, Russia or who cares, like pick your country, right? They're coming to us with clear vulnerabilities in our program that clearly has value to us to remediate this. Can we pay them and set up a program structure that will allow us to engage with them, right? But turn to legal, right? I mean, you're not the lawyer. You shouldn't take incumbent upon you that risk. You should go to them and tell them, this is what's happening. Like, what do you suggest we do? If they say, we don't know, then you say, well, I'm not the lawyer, so if you don't know, then I can't take that as an effective response, so I'm going to defer to you. I'm going to refer them to you to figure out what to do with them, because I am not the lawyer and I'm not comfortable making a decision if we can pay someone, because that's a legal decision.
And that is a good differentiation between outsourcing to like a corporate group that does the bug bounty programs where you've kind of given them the authorization. Because that's the fine point around there is what's authorized and what's not authorized. And maybe if it's an unknown researcher reaching out to you the first time, you would definitely want to figure out if it is allowable. How do you kind of clarify that under safe harbor and what those requirements are?
But you're the CISO. Not your job to know. It's your job to go to the lawyer and say, hey, look, these guys are coming to us. These are the contracts. This is what it says. Can we pay them? Right? I mean, it's a functional legal decision that, I mean, I'm not a GSA specialist in contract law, so I'm not, like, I mean, it is, and you have to look at it, and someone has to make that analysis and then give you an answer. If they can't give you the answer, my advice to you is send the hackers to the lawyer, because at the end of the day, it's not your job. Yeah. Any questions you ask us, I'm assuming are hypothetical, and any answer I'm giving you is a hypothetical situation as to how you should handle it. This is more about risk assessments. These are some questions you can ask, to figure it out. I'm sure you're all security professionals have seen these things before, so I'm going to skip right forward. So, rumor, you will be prosecuted for paying ransomware. That is actually can be true if you pay a terrorist. Right? But just so you understand the equivalence, if you decide to fill up a bag of cash and walk it over to Al-Qaeda to buy back employees, and then that money is then used to bomb the United States interests, that would be a problem under OFAC and a bunch of other things. So what you should do is, they say pay a ransom. You say, I will consult my lawyer. And your lawyer will then retain, hopefully, there are cyber lawyers. There are a couple some are really good, some are but you'll figure it out. Right? And they will tell you but you're the CISO. You're not supposed to make the decision about whether to pay or not pay. Your job is to say, if we pay and we get a key and they can decrypt the information and we can access things, it will make recovery easier. Or it may not. You may be like, our backups are fine, I wouldn't pay the ransom. But your job isn't to make an illegal analysis as to whether or not the company or yourself should be making payments to somebody that's a third party. And they may say, well, you can help us figure out who it is. You can say, I can look in the phone book. I mean, you can say, I'll refer you to somebody, right? But at a functional level, your job is to advise them as to the impact of that situation from a technical capacity and then inform them.
And there is an obligation. I mean, Daniel mentioned obviously reviewing, make sure that you're not paying somebody that's on the OFAC list. But there is an obligation that if you're actually considering making the payment, because again, you're paying these guys in crypto, is that you've done some due diligence and you'll want to contract usually with an outside counsel or a third party to do the actual research, because what they'll do is they'll look at the wallet, they'll look at the tracing to see who is it potentially affiliated with, because that kind of goes back to if it's a wallet that's affiliated with North Korea, you're gonna have a bad day if you make the payment.
David's 100% right, but again, you guys need to be given the parameters of permissible payment. right? You can contract with a third-party vendor to get you the data about them, but you're not the ones that are specialized in national security law, right? Or FinCEN law, or whatever the particular, and then there's specific other industries. Like if you're in the DoD space, right, and you're compromised, depending on where you sit in the food chain, right, you may have 48 to 72 hours to tell certain government agencies you've been compromised, and they reserve the right to come to your computer systems and do whatever they want, whenever they want. And they can send in their own teams to do whatever analysis they feel is permissible. And they may advise you to make or not make any said payment, right? So it's sector specific. And it's very important that when you do that analysis, you're looking at, question, yeah?
Yep.
This is really hypothetical.
Everything's hypothetical as far as I'm concerned.
This would be really unethical, but I'm just curious how the law would work. So what happens if a company gets hacked and it was not part of the bug bounty program, but instead of them reporting it to the SEC as a hack, that they say, oh no, we decided to pay this person and this was part of our bug bounty program to avoid the 4-day reporting to the SEC and having
Yeah, so the problem, there's a lot of problems.
Well, it depends. It's a very, again, fact. So the first thing when you do this analysis is it a material cyber incident, right? The SEC guidelines, people start 48 hours, like GDPR, right? That's all hogwash, right? It's a material cyber incident. Now, there's a question of whether a lot of little cyber incidences can become a material one, which is this gray area the SEC hasn't provided guidance, but that's
and the event that happened, I mean,
Yeah.
what does it fit within the terms of your bug bounty program?
Yeah, but
because the
well, they
tone of
didn't
the
have one.
contact, all of that is going to be looked at.
Yeah, but say you didn't have a bug bounty program and you paid them anyways. Who cares? The point being is that that's a business decision that's driven by legal guidance. So if it's not a material cyber incident, it doesn't raise to the level, didn't cause material harm to the organization, and you've consulted outside counsel and they're like, okay, they found a security issue, pay them, right? That is your decision. Did they break the law? Did they hack? Did they unauthorized obtain access to your network? Say they sent you a 0-day and they achieved access and whatever, okay? Yes, they broke the federal law. Do you have an obligation to report them to the U.S. attorney? Probably, again, if you're in a government contracting space, different space. But depending on where you operate in the sphere of corporate world, who cares?
But I think it was more along the lines of, is it an incident or is it a bug bounty at that point in time? And that's
It's always
where
an incident. Yeah, but a bug bounty is an incident. It's just effectively the channel in which you're going to,
But from a
they've
reportable-
obtained unauthorized access to your system. The question isn't about, is it reportable or is it not? That is tied to, was it material? You could have a bug bounty, and if they find a material security issue with your organization, that's a different conversation. But again, outside counsel, your legal team, security officers aren't in the position to look at the law and figure it out, right? That's the whole point, right? There are there's a great trial lawyer, Mofo. She headed up the SEC's trial teams, right? And over the last 10 years, she tried some of the biggest cases. She is a rock star. And then you've got Avi, Guest. There's some really good lawyers, right? And this is what they've done, right? So you look and you consult people that know that, just like a lawyer shouldn't make a determination whether or not to turn a firewall on and off. I mean, God help us. Can you imagine a lawyer making a determination about endpoint security deployment? You're lucky if they can turn their phone on. If they push patches. I just, functionally speaking, so the two lawyers in the room, but okay, no, I still stand by it. We deal with federal judges that don't patch or upgrade. See, you wouldn't expect a lawyer at a functional level to help manage your security program because they don't know nothing about it, right? Similarly, you're not in the same position like 99% of the lawyers in the world that are chief security or work in information security are not practicing lawyers, advising their company, and serving in that role. Most people are information security professionals. So you would consult somebody that specializes in what your corporation's legal responsibilities are. Your personal responsibility is triggered if you've signed sworn statements, if you submitted deposition testimony, if you've told people things under oath, penalty of perjury, and people have relied upon it.
And I would just make sure that it's very well documented on the rationale of why you decided to go a certain route. This way you can say that you considered both alternatives and maybe it was not the right alternative, but at least it was documented and there's
Always document it, and here's why. Law is not, I tell people this, practice of law is not like Law and Order. It doesn't finish in 45 minutes without commercials, okay? You don't get ding dong every time you go out of court, right? It takes a long time, right? Between an incident and actual first filing of a class action, I think it's fairly fast, like 90, 120 days. But between the filing, the response, and everything else is years. So in all likelihood, what's the lifetime of a CISO or security?
It depends whether or not.
I can't remember. David knows
It
all
depends
these
on a
things.
lot of things.
But is it like a couple years, right?
So I mean, the average turnover among CISOs is usually about 2 years, or a little over 2 years from that point of view.
You should always document what you did because the narrative may change based on how the corporation sees it. So by you documenting your narrative as you saw it through your lens, there's no ambiguity downstream. So that is clearly defined. But I mean, I would recommend putting a bug bounty program in place at some functional level if you intend to use it. But somebody can reach out to you if you don't have one and say, I found a huge flaw.
Yeah, I mean, we take into consideration then, like, the tone of the email is very important.
Yeah, if
As
they
again,
say
we talked
pay
to
me
that.
money or I'm going to tell the world, okay, I mean, you know, yeah, go ahead.
So what about you coming in from this from the ethical hacker side of things? Verbally, theoretically, the community of ethical hackers connect them to companies looking for bug bounty,
Yeah, sure.
hunters. Like, so would we be taking on a lot of legal risk if we don't vet those people well enough when we connect with companies?
So you would definitely want to vet your applicants, and you definitely want to have a means of making sure that whatever the rules of engagement that are defined, that it's stuck to. Like if you don't want somebody dumping the data in the S3 buckets and taking it,
So
it
there's
should
business
be,
risk and there's legal risk, right? So at a functional level, if you're hiring a bunch of ethical hackers and they're not going to follow the rules of the people that put together the program, you're kind of toast, right? Your business is going nowhere. And probably they're going to get in quite a bit of trouble, right? Because it's a fine line of engagement, right? And so it's an interesting dynamic of when you have to tell the federal government, or if you want to tell the federal government you've been hacked, right? They want you to tell them that, but you notice they don't come to you and say, you must tell me. The FBI doesn't come to you and say, you must tell me if you've been hacked. I mean, the federal government, the DoD, you must tell them. But there's only a handful of companies in the world that must disclose incidents, all incidents. Most companies have an obligation to disclose material incidents. But if you're a privately held corporation held by two private dudes that own, a $5 billion company, and you have no shareholders and there's no harm to anybody but them, right? That's a different area of discussion. But generally speaking, you just have to remember that your job is to secure the organization, not provide legal guidance about what you can and cannot do.
And
right?
just
And
like,
so, but if you hire hackers that you know are going to commit crimes, I mean, it's not a good look for your business, and you probably may be labeled as a criminal syndicate. But I mean, again, like if you're hiring people that are ethical and you're managing the business part because they don't like the business part of reaching out and reading the rules and they follow the rules and guidelines, there's nothing wrong with it, right? I mean, you're managing a part of the functional process. It's like being a talent agent effectively, and you just, I think talent agents, they take 10% cut. They take a default cut, 10% of everything you earn, right? So I mean, but it's functionally, if you hire a bunch of talent that turns out to be horrible people, you're going to make no money.
and I think also, having the conversation with the organizations around materiality, what does it mean for your organization, is very important. Because a lot of times, lots of small, consistent things that may not have been material taken independently result in
So this is
pretty consequential damages.
So what David's talking about is the Securities Exchange Commission has proposed these rules that says, if there are a bunch of little cyber incidences, does that end up in its collective view, could it be interpreted as material? It is a gray area right now as to what that means. But I mean, again, you're the information security professional. All you got to do is tell the lawyers, we've had a bunch of little incidences, here they are. Thank you very much, right? I mean, it's not like you need to tell them, oh, you need to tell the SEC or you need to go tell somebody, right? And I was thinking, if you hired a bunch of talent that ended up killing people, I think that would be a criminal syndicate and you probably could be criminally charged. So I mean, maybe in a similar way, if you hired a bunch of ethical hackers that turned out to be super unethical and ended up committing massive amounts of crime, you probably maybe end up being criminally liable, possibly, depending on if you knowingly and willfully participated in collecting the money and ransoming corporations, because that is by definition of criminal gang. So, I mean, as long as you steer clear of that, I mean, you should be okay.
Yeah. Any other questions so far? Let me flip the next slide.
Yeah. Yeah. So this is really important. This is like, for those of you that are parents, I tell my kids, don't lie to me. Just tell me you don't want to tell me the answer, okay? Right? But if you go tell the federal government a lie and then you sign something that says, if you sign this and you know that you're lying when you sign this, we can charge you for a crime. So as a CISO, I have to stress to you, you should read these things before you sign them. If you're not comfortable signing them, here's a newsflash, don't sign them. There's no, like if you feel the peer pressure to sign something, you have one of two choices. You either quit or you tell them to hire outside counsel. But if you full well know that what you're about to sign to launch the Artemis mission into space, it turns out that it's not what they say it is and can result in massive loss of life, what do you think is going to happen if that thing blows up? And you knew about it. So you knowingly put a system into operation that could result in the loss of life, signing the form, full knowledge and consent. It can't be I felt peer pressure and that's why 7 people are dead. Right? That's not how the United States works, certainly when you sell to the United States government. So it's very important that if you're making these representations as the information security executive, signing that, you realize the risk you're taking. And if it turns out you're wrong, that's okay. You can go back and say, I made a mistake. I was wrong. Right? There's not, like I make lots of mistakes. You can ask my kids or my wife. I make mistakes all the time. Like around the clock. So the important thing is about acknowledging them and making people aware of them. If you don't tell them, like I'll give you an example. If you don't tell anybody and then you go before the board and you recommend that the settlement offer the government's giving you is good, even though you full well know that you haven't disclosed all of the other incidences, that's probably going to be problematic. Right? So, I mean, it's a pretty simple principle.
And it's not just, as Daniel mentioned, it's not just the FCA. There are plenty of other regulators with plenty of other requirements around, truth and disclosure.
Healthcare, OCR,
Pretty much every industry has one.
Yeah, energy, NERC, FERC, SIP. I mean, there's every sector. The United States it's kind of bad news, right? We have sectoral regulation, and then we have state law, and then you have federal law. So it's like a hot mess. So the theory is we have a question.
Yep.
Sorry.
Oh yeah, could you clarify on the False Claims Act and some of the stuff you've been talking about, the difference between the civil liability and criminal liability?
Yeah, so you become criminally liable if you submit a sworn statement to the federal government in a federal contracting process and you sign it under penalty of perjury, acknowledging 42 U.S.C. 1001, which says they can charge you, or under the False Claims Act, you can be criminally charged. It's just straight up. It's like selling
and if you're the
bad
designated,
guns to the U.S. military. They're going to charge you because people die. I mean, it's just because it's cyber, you think, oh, it's not the same thing, but it's no different in the eyes of the government, right? Selling a defective AK-47 and signing a statement saying they all, or M16 and they all shoot just fine, it's the exact same. It's just one's digital and one's physical.
And if you are the, go ahead.
100%. If you hit criminal, you're already screwed civil.
No, but let's say.
Oh, so you get civil?
So you don't get criminal.
Oh, okay, so you're always civilly liable. So government, DOJ collected something like $2.5 billion last year and other false claims under this act, okay, and penalties, right? So they're pretty aggressive about it. So there's civil liability. A lot of, like 3M settled for the earplugs. They said that these earplugs would work and people wouldn't go deaf. Turns out it was a brazen lie, and 200,000 people lost their ability to hear. And the United States government settled with them for, I think it's undisclosed amount of money because they sold a bunch of earplugs to a bunch of people in the military that resulted in them losing hearing.
Yeah, and if you're the designated individual giving testimony
Oh yeah, it's this one.
to regulators, you need to keep that in mind also, because now essentially you are a binding official of the company and you are making statements on behalf of yourself and binding the company.
Yeah, I mean, it's simple. Like, if you are elevated in position in your organization and you make statements to a regulator under, certainly sworn statements, okay, slam dunk. If you make statements but they're not sworn and you're sending, and This is why you use lawyers, right? All you have to do is talk to your lawyers and let them figure out what to tell them. What your job is to do is to inform them in a way that they understand what's happening so they can make decisions about the legal advice. If they're asking you to lie to a regulator, say no and report it, right? Nobody is required to lie on behalf of their company to the United States, to anybody, frankly, but certainly not to the US government, right? It's not like to get hired, you have to lie, right? That's not the selling pitch. So I think that at a functional level, it's, you know, a pretty clear thing, right? But I think...
And there are plenty of times, I mean, as a former regulator where organizations have come to speak with me where they do not have the immediate answer to the question, or they give me a very broad answer, and they'll be like, I will come back to you with clarification, or I will get back to you. So you don't have to feel the need to make a misstatement right out of the gate. It's better to be, I don't know, or let me get you more detail.
You as the CISO, if you want my opinion, shouldn't be making the statements unless they call you to the principal's office. So like, you as the CISO should be talking to legal, who should be talking to the regulators. If the regulators come back and say, we want to talk directly to the CISO, then you go, but then you're prepped. You have outside counsel, you have, if you want my honest opinion, I would actually hire my own lawyer because at times the company's interests and your interests may diverge, right? So your company lawyers, everybody understands, they represent the interests of the corporation, not of you, right? There's a big difference. Right? So at some point, if you feel that is getting gray, you should hire your own lawyer to advise you as to what's the appropriate thing for you to do, not for the corporation.
And if you are a financial services CISO, you will be speaking to the regulator. Yeah, and there are certain categories. If you're a energy CISO for in nuclear, you will be speaking to the regulator. So there are some categories where it's not optional.
Yeah, okay. And hopefully you get paid more. No, okay, the point is that yes, if it's not optional, but you should always consult with your legal team about what, and if you ever feel that it is diverging, you should hire your own lawyer to advise you, not a family law lawyer, like a white-collar crime lawyer or like a lawyer that is trained and skilled in that area, because they're going to help you figure out what represents your interests. It may cost you $800 or whatever it is for a couple hours at a time, but it's well worth it. These are some general ideas. If you do have a bug bounty, you should go back and just look at it and make sure that you're comfortable with whatever the parameters say. I would conduct some sort, I'm sure you all have this in some cadence in some form or another. This is just some suggestions. I think that's it.
Yeah, so any questions? I think we have, 5 minutes left or so?
We can ask you questions. No, I have questions. One of the questions I was wondering from where you guys sit is that one of the things that if you think about it practically, as a chief security officer, it's a pretty intense job, like all around, right? I mean, they only have to be right one time. You have to be right every day, all the time. The bad guys got to only get it right once, right? And so when you deal with that, so that's your day job. Then you got to manage the business piece of it, right? Of all the people and the finances and whatever. How many people here work with legal team or legal counsel on some sort of regular basis and trying to figure out where they're going or what's to do? Yeah, and if you don't, I would encourage you, depending on how you fit in that organization, I would encourage you to have that conversation. Because it's already a hard enough job that you're dealing with, that if they come to you and say, should we pay the ransom? Your answer should be, if you pay the ransom and we get the keys, this is what we can do. Or if they say, do you think, like this is a common question I hear when I sit in these meetings. Well, if they pay the ransom, do you think they're gonna give us the keys? I'm like, they're criminals. How is this gonna know any? You're gonna get threat intel from somebody that says 6 out of the 10 times they paid it and this is what they want or whatever, right? But at the end of the day, that's managing risk based on information that they've accumulated from criminals. Is it good? Depending on who your source is, some are better than others. But I think at a functional level, right, unless you run like a gigantic company where you have, like I only know a handful of companies in the world that have their own threat hunting and intel teams and everything. Like usually you're relying on third parties, right? And you're taking the information and it's the same data, but they always ask the CISO, should we pay it? Do you think they're gonna decrypt? And you're like, well, I'll go ask my buddies and look at the same information you're looking at.
And I would just mention too, to Daniel's point, just like in that construct of incident response or anything else, you want to have a good working relationship with your legal counsel before the shit hits the fan.
Yeah.
Just like law enforcement or a regulator, their first call to them shouldn't be oops or like this happened.
Well, just think about it. If they don't know who you are and you walk in through the front door of the FBI and you got blood all over your body and be like, I just tried to save someone's life, they're going to be like, yeah, sure. Right? I mean, they'll be like, good luck. But if you know them and you've worked with them for 15 years and they know who you are and you're an honest person and you engage and you work part-time at the local police department as support and you walk in with blood all over your body and say, hey, look, this is what happened, they're probably more likely going to believe you rather than throw you on the ground, arrest you, and stomp you. So, like, the point being is that it's very important to have those functional relationships so you can engage in a conversation because relationships matter. With all that said, I think we've hit our time and we thank you so much for participating. We learned a lot from you guys. Thank you.
Thanks.